To everyone. I hope you are all having a great Tuesday. We have another packed program for you today. One thing that I would point out is, in addition to the surveys that Kathy just mentioned, please make sure to put any questions you have in the Q&A box. I know that we don't always have time to get to them, but I will tell you that we review them every week and they really steer the topics that we talk about in the week or two after that. So please make sure that you're engaging with us today. I think we're going to have some time for me to go through some of the Q&A, so please feel comfortable putting your questions in that box. All right, first up today, we have Hannah Redmond. Hannah is an attorney in our Syracuse office. She works in the Labor and Employment Department. And Hannah is going to give us an update on what is going on with the pandemic. So Hannah, please take it away.
Thanks, Adam, and hello, everybody. Today, we're going to look at some COVID stats. Where do we stand with COVID? Where were we? Where are we? And where are we going on a national, state, and local level? Next, thank you. So here we're looking at national stats for positive cases. These are newly reported cases over the last 90 days. Looking at the last third of this chart, which is January, you see a significant peak. And now we're seeing a dramatic decline in cases. That peak where it says new cases, more than 1.4 million positive cases were reported, and that was on January 10th. So since January 10th, we're starting to see a downward trend. We're going in the right direction. On January 30th, only 116,000 new cases were reported. So we're seeing a dramatic change. We're tracking in the right direction. Looking at some of our key data points that we've been tracking all along: cases, tests, hospitalization, and deaths. We're seeing a dramatic decrease in positive cases and in hospitalizations. Since from January 14th through 28th, we saw a 35% decrease in cases nationally, an 8% decrease in hospitalizations nationwide. Tests are increasing, and unfortunately deaths have not yet seen the kind of drop we're seeing with cases and hospitalizations, but as positive cases and hospitalizations begin to decline, hopefully we see that death toll going down as well. This is where we stand with vaccinations nationwide. Looking at all ages, 75% of people have received one dose, 64% are fully vaccinated, and the CDC has reported that of those who are fully vaccinated, 41.5% have received a booster. For those 12 and up, 85% have received one dose of the vaccine, and 72% are fully vaccinated. Now, looking more closely at New York, where I know a lot of you are and where we all are, we're seeing the same trend. So the graph looks very similar to the graph we saw for national cases. We're seeing that peak right around the first 10 days of January. I think the peak here was January 11th. And we're seeing an even more dramatic decline in positive tests in New York. Again, seeing a drop in cases and hospitalizations, much like we saw nationwide. We have a 75% decrease in positive cases being reported from January 14th through January 28th. Hospitalizations are down 31%, seeing really good progress in both of those categories. Tests are also down in New York, and unfortunately, we are still seeing deaths tracking upward. Again, hopefully that stat begins to catch up with the cases and hospitalizations. Looking at the three graphs on the top there, it's kind of hard to see, but we are beginning to see downward movement in all main categories. Looking at New York vaccination rates, as we've seen throughout the pandemic, New York is vaccinated at a higher rate than stats nationwide. 87% of New Yorkers have received one dose of the vaccine. 74% of New Yorkers are fully vaccinated. Of those 12 and up, 95% have received one dose, and 83% are fully vaccinated. This graph is from the New York State Department of Health. It's showing hospitalizations in all regions of New York over the last 90 days. Again, we're seeing the same pattern. The numbers look the same. We're seeing that peak in early to mid-January, and now we're seeing a dramatic downward trend. In January 11th, which is the peak shown on this graph, there were 12,671 hospitalizations statewide. By comparison, on January 30th, there were only 7,191 hospitalizations. So we're still seeing more hospitalizations than anyone would like, but the numbers are going in the right direction. And then finally, this shows vaccinations and hotspots on a county by county level. If you look at the vaccination map here, you're seeing that nearly all of the state is at least 60% vaccinated in each county. There's still a few counties that are tracking lower than 60%, but most of the state is above that range. In hotspots, you can see most of the map is quite colorful. We're still seeing high infection rates in much of the state. In a few counties, you see that dark red where we're seeing even higher infection rates, more than 100 people out of 100,000. So that is where we were, where we are now, and hopefully where we're going. We're continuing to track this. Hopefully we continue to see downward movement in all of the key COVID data points. We will keep you apprised.
Thank you, Hannah. It's very important, I think, at this point to take stock of where we are in terms of cases, hospitalization, and deaths, because there are a number of regulations, at least in New York State, and rules that are based upon the progress and the status of the pandemic. So, for example, I'm going to talk about the mask mandate in a little bit, and we know that there are certain things that are expiring in February, and whether or not the government is going to extend those rules depends largely on where we are in terms of the pandemic. So, good reminder. Thank you, Hannah, for that updated information. Okay, next, we are going to turn to a topic that we think is very important for employers that may be overlooked. And to present on this particular issue, manual pay, worker pay issues, is Greg Riley. Greg is a member in our New York City and New Jersey offices, and he has a presentation for you about this topic. So Greg, please go ahead.
Thank you, Adam. Next slide, please. So what's this about? Well, first of all, I hope none of these listeners have this issue, but it's certainly conceivable that you may have it. In New York State, they have a rule. It's a part of the labor law that says if you're a manual worker, and we'll get into what's a manual worker, but if you're a manual worker, you have to be paid once a week. I'm handling some cases right now where the employers paid biweekly. They paid what was due, they paid, everybody got paid in full, but instead of paying their manual workers, and I've dealt with this with several clients, instead of paying them once a week, they paid them twice a week. So one might sit here like with some common sense and say, well, who cares? They got paid. They got paid everything they're entitled to. But that's not how some of the courts, in fact, quite a few courts have looked at it. They have found that if you fail to pay manual workers on a weekly basis as required by the New York State labor law, you can have significant liability, which we'll get into. There were cases that dealt with this before 2019. And usually those prior cases before 2019 dealt with things like you would normally think of people who are manual laborers, like construction workers or plumbers or carpenters, things like that, people that work with their hands or engage in strenuous labor activities. That's changed. And probably the biggest case that changed it was this one that's on the screen there, called Vega versus CM and Associate Construction Management. The Vega case was significant because it came back, the appellate division for the first department. The case originated in the Bronx, but it was taken up on appeal, and the appellate division for the first department looked at a complaint that was alleged, just what I kind of described. The worker claimed that he was a manual laborer. He should have been paid once a week, but he was paid twice a week. The defense said that doesn't make any sense. He got paid everything he's entitled to. And in any event, the defense said that's something that the commissioner of labor should be deciding, not a court, because they argued there was no private right of action. That the court was the inappropriate remedy, that if there was a complaint, you go to the commissioner of labor, and New York State Commission of Labor would determine if there was a pay violation, and if there was, the commissioner would determine what the appropriate remedy is. In the past, it used to just be a fine. Anyway, so what happened in Vega is that this appellate division decided that there was a private right of action. They claimed it was expressly under the statute. But then to cover their bets, they said, even if you couldn't find it expressly under the statute, it's implied. So they said it's implied because these labor and employment laws related to payment of wages are to be interpreted broadly in the worker's favor. So they said they think there's a private right of action either by statute or implication. The thing that caught a lot of people's eye about this decision, though, was they're finding that even though the workers got paid what they were entitled to, they found that damages could be imposed for the late payment. And what's the amount of damages? Well, it's the amount they were late paid. So if you have a 52 weeks in a year, and you're paying people biweekly instead of weekly, you could be liable, according to this decision, for 26 weeks of pay for the full amount. So that was kind of eye-opening. And I don't necessarily agree with the decision, but that decision started as we'll discuss, kind of a landslide of other plaintiffs' counsel. And there's a cadre of attorneys that do this work in New York, plaintiffs' counsel, who bring these claims because they saw the possibility of bringing claims for workers who were misclassified, or excuse me, who were actual manual laborers or manual workers who weren't paid on a weekly basis, and that there could be substantial damages here. So can you move the slide to the next one? Thank you. Anyway, so I'm not going to get into this in great detail, but I did think it's important to know, well, because this whole thing, it's based on, well, is somebody a manual worker? What is a manual worker? When are you entitled to be paid on a weekly basis? Well, the definition here basically says that you got to be paid weekly. And then there's another section of the law that says if you're going to be a manual worker, all you have to do is spend more than 25% of your working time engaged in physical labor. But the Department of Labor interprets what physical labor is pretty broadly. So there have been cases and other interpretations by the Department of Labor that have found workers that you wouldn't necessarily think of as manual laborers, like supermarket employees or hairdressers, janitors. They've been found to be manual workers. So it just because to my mind, at least prior to 2019, you always thought of strenuous labor or somebody who's working with their hands outside lifting heavy objects. That's not the case. As long as they're doing something that requires 25% of their time engaged in physical labor, they could be a manual labor, a manual worker, and they have to be paid once a week. The other thing I guess I'd point out in the second paragraph on that slide, it says 25% of working time. Well, you know, nobody's sitting, that's how the Department of Labor defines it. And it's in the statute. What is 25%? Nobody's doing time work studies and figuring out how much of the work fits in with, you know, physical labor or not. So that creates an uncertainty and a place for argument, which encourages the plaintiff's bar. And as said, the potential for significant damages also encourages the plaintiff's bar. So next slide, please. So what are the risks? Well, in New York State, claims for unpaid wages go back 6 years. And 6 years is a lot, because if maybe not for one individual worker, it could be a lot for even an individual worker. But if you have a group of workers who were not paid on a weekly basis, you have the makings of a class action. So if you had 20 or 30 facilities in New York where you had people who were getting paid biweekly and they should have been paid weekly, and you go back 6 years and there's hundreds of employees, there's potential for hundreds of thousands of dollars, if not millions of dollars of potential liability. Plus, in New York, unpaid wages, you can get double the amount that's owed. So that's called liquidated damages. So that adds to it. Plus, and this encourages the bar, the plaintiff's bar, the plaintiff's bar is entitled to attorney's fees on the, you know, for doing their job or what they, you know, what they're trying to do would get money for their clients. They're entitled to their fees. Plus, they're entitled to interest on the unpaid amounts. So this is a significant potential liability for a lot of employers who may have been mistakenly not paying on a weekly basis. They weren't trying to, I think most employers aren't trying to cheat anybody or you know, violate the law intentionally, especially on something like this where they're going to pay the people. They just pay them once every 2 weeks instead of once every week. But it's almost kind of a gotcha thing that has been created in the law. So what happened after 2019 in this Vega case that I referenced earlier is a bunch of other cases happened, not surprisingly, given the potential, you know, for class actions, and there's been quite a few class actions. There's been a lot of cases where these claims have been made. The case law there's been cases that go the other way and say, you know, the Commissioner of Labor has to make the decision. There's no private right of action. There's cases that say that interpret whether somebody is a manual laborer or not, and were they covered or not by the statute. But the case law generally is unfavorable. Not every case, and there's exceptions and there's defenses, which we'll get into. But most of the cases aren't so good. And the fact that you have this 25% rule, which is a little difficult to interpret, and you got the potential for high liability. A lot of these cases, there's like I don't know, hydraulic pressure to settle class actions based on these kind of claims because of the potential risk. Even if you have defenses, sometimes there's this hydraulic pressure to settle because you don't want to take the risk of a bad ruling. So that's kind of what's going on. There was a case recently in September 2019, a Petco case out in the Eastern District, Federal Court, Eastern District of New York, where the court denied a motion to dismiss one of these manual worker claims. And it basically said the case law is generally not in the employer's favor on this stuff. And that it did note correctly that the New York State Court of Appeals, the highest court in New York, has not ruled on this issue, but there's appellate division decisions that are unhelpful, and there's some federal court cases that are unhelpful. There's defenses, we'll get into it, but this is like a risk that employers should be aware of and give some thought to if you have workers that may be or could be determined to be manual workers under the statute. What are the potential defenses? We talked about some of them. No private right of action. That doesn't necessarily fly, depends how the case law develops. Some in the Petco case, the defendants claim that there's no federal court didn't have jurisdiction under Article 3 of the Constitution because there was no case or controversy, which I thought was pretty inventive. No case or controversy because the employees got paid. So what's the court to do? Why are we litigating about this? But the court rejected that. And the court rejected it because I want to give it from the employee side and what the court said. They view it as the employees are entitled to get paid weekly. And if you don't pay them on a weekly basis, they're out of the value or the use of their money. Also, some of the case law, including Vega, said, well, the other thing is if there's a law that has no remedy, that's a problem because there's no way to encourage employers to comply, and a lot of the wage and hour laws are pretty harsh and almost punitive in how they treat violations. So in Vega, they pointed out that it's the use of the money, or in the Petco, they pointed out it's the use of the money. In Vega, they pointed out if you didn't impose the liquidated damages, there'd be no real remedy. So that's an issue. Of course, you can always argue that your workers are not manual workers, but again, can be a fact question. Things like job descriptions could affect that determination. So if there's questions on that, you may want to look at your job descriptions to see how your jobs are described. That may be helpful or unhelpful to your position. The other potential things to bear in mind, if your workers are unionized and there's a collective bargaining agreement, the collective bargaining agreement can set the terms differently than the New York State labor law. So if the union agreed and as part of a CBA, you could have them paid bi-weekly. That would be a defense, or not a defense, but it would be an exception to the statute. Another thing to consider if you've got some doubts, at least and you haven't faced any litigation, but think about analyzing your workforce, see if you've got manual laborers, and if there's any doubt, think about switching from paying them once every 2 weeks to paying them every week. Today's the Chinese New Year, first lunar month. It's like a new time, and maybe you implement a new payroll system for those workers to get them paid on a weekly basis. It won't necessarily stop you from having liability in the past, but it could clean you up for avoiding potential future liability. There's one other thing, if you can switch to the last slide. There is a carve out that's in the statute and permits the New York State Department of Labor to give some big employers an exclusion or a waiver of the bi-week or the weekly pay requirement. It's pretty, those are the requirements on the slide. But you got to be pretty big, and you have to submit an application. And there's other factors considered, like they're not going to grant your application if you have prior wage and hour violations and you're not a good employer. and other kinds of labor and employment law areas. So it's hard to get those carve outs, and but that's something that might be an option. The other question too is, even if you can have one, it's not clear to me that you can get it going, retroactively, but it might be an issue, a way to proceed going forward. So that's it in a nutshell. I just wanted to bring it, and I'm glad to have a chance to talk today. I just wanted to bring this to people's attention because we're seeing a lot of these cases coming up, and they're brought as class action. The defenses are difficult. They're not impossible, but they're difficult. And they do, because the potential liabilities, create this hydraulic pressure to settle. And hopefully the issues associated with manual labor pay could be avoided by some of our listeners. And if not avoided, certainly mitigated.
Thank you, Greg. That was great. We got a lot of questions. We will take a look at those. Wage and hour litigation is unfortunately very common. I represent a number of clients in wage and hour cases. They take many forms, whether it's failure to pay overtime, failure to pay a required tip credit, or these failure to pay on time type cases. Typically, they're made in a class action where you have a number or many different plaintiffs getting together saying you're doing the wrong thing. So these are great, helpful tips. And if anyone has any questions about wage and hour, a wage and hour case, or any specific issue relating to your company, please feel free to reach out. Okay, so now we're going to move on to some COVID topics, and I am going to handle mask mandates and then some of our most frequent COVID paid leave FAQs. So let's get started with current mask rules and regulations. This has been in the news lately because of some recent court activity, but I wanted to back us up. First, help everyone understand where we are and where we have been in terms of mask requirements, and then what's going on with the courts and what's the law and the status of the law right now. So first of all, what are the current rules and regulations that are in place in New York State regarding masks? So first of all, we have 10 NYCRR 2.60, which is the rule that is the subject of all of the litigation. This is the rule entitled Face Coverings for COVID-19 Protection. In the chat, I have actually put links to all of the different documents that I'm going to be speaking about. We had a lot of comments. People asked if I could do that, so I did that beforehand. So if you open up the chat, you can actually open up these documents as we go through them. So first of all, we have this 10 NYCRR 260. Next, we have the Health Commissioner's determination on indoor masking. This is the document I think that everyone is familiar with. I'm going to walk us through what this document says in just a minute. It was most recently updated yesterday, so the version that I provided for you in the chat is the most recent version. Next. Finally, we have the New York State HERO Act, which hasn't gone away and hasn't been implicated in any of the recent court cases. So I want to touch briefly on what that says as it relates to masking. Next slide, please. Okay, so let's talk about this Health Commissioner's determination, the most recent version of which is from yesterday, January 31st. What does it say? Well, it lays out, first of all, a justification. I don't have that here, but it talks about why the Commissioner of Health is putting out this regulation or this rule. It then goes through a number of specific settings. So the first setting it talks about is the healthcare setting. I'm not going to cover all of these, but what it says with respect to the healthcare setting is that visitors and personnel have to wear masks while they are in the healthcare setting. With respect to personnel, it says at all times. With respect to visitors, it gives that caveat that we've heard many times. Visitors who are over the age of 2 and medically able to tolerate must wear a mask. Importantly, this requirement does not or is not affected by whether or not you are vaccinated. It's regardless of vaccination status. Next slide. Another setting that is discussed in this Commissioner's determination is the school setting. This becomes particularly important in the litigation that I'm going to talk about in a minute. with respect to the school setting, it says that there has to be universal masking for teachers, staff, students, and visitors, again, over the age of 2, medically able to tolerate. It also says that the rule applies to any, quote, gathering on school grounds, which addresses or implements educational matters where students are or may reasonably be expected to be present. So this is going to impact your extracurricular activities. If you expect students to be present on school grounds after school hours, then you're going to have to make sure that there's a mask requirement in place. Notably, the mask rule does not provide for mask breaks or an exception based on minimal social distancing in classrooms. So masks have to be worn in school according to this guideline, again, regardless of vaccination status. Next slide, please. So I'm not going to cover the other specific settings that are addressed in the commissioner's determination, but here they are. Adult care facilities, correctional facilities and detention centers, homeless shelters, and public transportation conveyances and transportation hubs. So there's a separate section in this commissioner's determination for each of these different settings. Next slide, please. All right, most importantly, the commissioner's determination includes this all other indoor public places category. This is the catch-all. This applies to pretty much everyone else, or it does apply to everyone else who is not mentioned in those other specific settings that I discussed just a moment ago. So it says that all persons over the age of 2 and able to medically tolerate a face covering, regardless of vaccination status, shall wear an appropriate face covering in, quote, any indoor public place. So the regulation says it does not apply to any indoor public area that requires proof of vaccination as a condition of entry. And we'll talk about that in just a second. And now, as of January 31st, it is in effect until February 10th of 2022. Next slide. Okay, so what does the regulation mean by indoor public place? The state has a set of FAQs on its website, which we provided the link in the chat. And the FAQs tell us that indoor public place includes basically any indoor place that's not a private residence, including businesses and venues, either privately or publicly owned, indoor entertainment venues, concert halls, sports stadiums, recreational spaces, etc. Pretty much any indoor space that you can think of that's not your home or somebody else's home. It applies in office spaces as well. And this is something that clients have struggled with since the rule came out, because in the office section, it says that you have to wear a mask at all times unless you're eating, drinking, or alone in an enclosed room. There's no accommodation made for cubicles. Many offices have cubicles. According to this, individuals within the cubicles would have to wear masks because it's not an enclosed space. Next slide, please. Now, importantly, the guidelines also talk about, or the all indoor public spaces section also provides an exception. And that is if an employer or business has a vaccination for entry rule. So if a business or public place says you have to be vaccinated in order to enter, then this masking rule doesn't apply to them. The FAQs clarify, however, this can't be a mix and match approach. So you can't say vaccinated people don't have to wear masks, but unvaccinated people do. That doesn't satisfy the terms of the rule. You have to pick one approach or the other. It's either all vaccinated as a barrier to entry, or it's masking at all times. So you can't mix and match. Importantly, this particular provision or the FAQs also reference the HERO Act. So it talks about how the HERO Act designation requires employers to have their employees wear masks inside. And that's important for the litigation we're going to talk about in just a minute. Okay, next slide. Okay, so that's what we talked about what the commissioner's designation says. There's also the New York HERO Act, which sets forth a number of requirements for employers to have safety plans that must be adopted. Notably, the HERO Act doesn't apply to public employers. I'm not going to talk about everything that the HERO Act requires, just the one area of masking and how it impacts masking. I think, can you hit the button there again? So the HERO Act has a masking requirement, and it says that an employer shall require that employees wear appropriate face coverings when physical distancing cannot be maintained and in accordance with applicable guidance from the State Department of Health. So what the state is saying is that the guidance that I just read to you, the commissioner's designation, is that guidance and therefore requires employers to have their employees wear masks when social distancing can be maintained. So it's not, the HERO Act masking requirement is not as strict as the commissioner's delegation and 10 NYCRR 2.60. But the HERO Act does include a masking requirement. Next slide, please. All right, so recent mask related developments. We first had in November of last year this case from Albany County. It was an Article 78 petition, which is a method for an individual or an entity to go into court to get some quick or immediate relief. In this Massapequa case, a couple of school districts went into court to try to get this mask mandate overruled as unconstitutional. The Albany County Supreme Court denied the petition and had these holdings here, which are a little legal. In essence, the court said it is not unconstitutional for the Department of Health to promulgate this rule, this 10 NYCRR 2.60. The mask mandate, they said, is a valid exercise of the state's police powers, and the districts did not satisfy this arbitrary and capricious standard. So in order to succeed on this Article 78 petition, to get a public, the petitioners have to show that the decision made by the public entity was arbitrary and capricious. The Albany court said they failed to show that. So this judge found the mask mandate was constitutional and enforceable. Next slide. We then have this decision from Nassau County, which I think everyone is familiar with from last week. This very similar procedural posture. You had an Article 78 petition that was filed, school districts arguing that the mask mandate is unconstitutional. In this case, the Nassau County Supreme Court judge, who is on the same level as the Albany County Supreme Court judge, he reached the opposite conclusion. He found that the governor did not have the authority to enact 10 NYCRR 260, following the legislative curb on executive authority. If you recall, at the beginning of the pandemic, the New York State legislature gave Governor Cuomo a lot of leeway and a lot of authority to respond to the public emergency. That leeway and authority was curbed last year by legislation from the legislature. So the broad authority that Governor Cuomo previously had, he didn't have anymore, and Governor Hochul also doesn't have that similar authority. So this judge was persuaded by that curb on legislative authority, and he also was persuaded by what he saw as a usurping of the legislative role. He pointed out that the state legislature has the authority to enact laws, the governor and the executive branch does not, and by enacting this regulation without the appropriate statutory authority, the governor was engaged in lawmaking rather than rulemaking. So he found that it was unconstitutional. So now you have two competing decisions by judges that are on the same level. Next slide, please. So where are we now? We know that an appeal has been filed of that Nassau County decision that I just talked about with the Appellate Division, Second Department. And by way of just a little bit of background, New York State is broken into 3 levels of courts. You have the trial level, which is called the Supreme Court. Strangely enough, New York decided to use the word Supreme Court for its lowest court. So you have Supreme Court, you have an intermediate appeals court called the Appellate Division, and then the highest appeals court in New York State is called the Court of Appeals. Right now, this Nassau County judge, the Supreme Court level, he issued a decision. That decision has been appealed to the Second Department, which is an appellate division, the intermediate level. The appeal requested, the parties requesting the appeal requested a stay, which was granted by the second department. So that means that for right now, the mask mandate remains in place, notwithstanding the Nassau County decision. So it's still in place for now. As of yesterday, the second department issued a new control date of March 2nd. So we know that at least until March 2nd, this mask mandate remains in place. It may get, the stay may be lifted. The second department may issue a decision siding with the Nassau County Supreme Court. But for right, we don't know that yet. For right now, the mask mandate's in place and it will be until at least March 2nd. Okay. So that is where we are in terms of masks. Next, I want to just hit very quickly on some complicated COVID paid leave questions that deserve way more time than I'm about to give them. If you have any questions about these issues, please feel free to reach out. We're happy to talk. So first of all, what COVID paid leave is available? I always like to do this at the beginning of any discussion of COVID paid leave issues. First of all, FFCRA leave gone. It's no longer available. It expired at the end of September of 2021. We still have New York COVID paid leave, which I summarized there for you. Next slide. In addition to the text of the New York COVID leave statute, we have a January 2021 guidance document from the Department of Labor that provides some additional information for how to analyze COVID paid leave questions. Next slide. There's also paid family leave and disability that may be available to your employees if you have to provide those things in certain circumstances. For example, if they have to take care of a dependent who is under a quarantine order where they themselves are not necessarily under such order. Okay, next. Now let's do some FAQs. Do I have to accept the self-attestation forms for the purpose of providing COVID leave? Now, you're going to hear me say this on each question. The New York State or the statute, neither the statute nor the guidance document address this issue. So we don't have any clear guidance. What we know is that New York State and the many local health departments are utilizing these self-attestation forms. Is this a quarantine order? Well, again, the statute and the guidance don't address this question. The self-attestation forms themselves purport to be isolation and quarantine orders. They say they're legal documentation. They say that they are as if it was an individual order issued by a particular Department of Health. So we know what position the county health departments are going to take. They're going to say this is enough. Now, the statute says that the orders have to be issued by the state of New York, Department of Health, local board of health, or any governmental entity duly authorized to issue such order. Doesn't mention or say anything about self-attestation documents. So it's not entirely clear whether or not these self-attestation documents would qualify under the law as a quarantine or isolation order, thereby entitling someone or an employee to COVID pay. Now, there are risks involved with any approach that you take, and I would encourage you to discuss this with your attorney. Next slide, please. Kind of piggybacking off of the self-attestation forms are self-tests, at-home tests, which are incredibly prevalent right now. The issue for employers is obvious. There is a significant risk of falsification. How do you know that your employee, the picture they're sending you of a positive test is their test? How do you know they didn't go online and just copy a picture? There is a significant risk of falsification. However, employees are put in a very difficult position right now. PCR tests are not easily obtainable. Testing sites are booked. It's hard to get tests. So this presents a problem for employers. Again, the text of the statute or in the guidance document from the Department of Labor don't address this issue. There are a wide range of approaches. I've listed a couple here. You could just accept the at-home test with nothing more. Some employers are doing that. Other employers are requiring the at-home test with plus, let's say, some additional proof. If your county allows individuals to self-report, You might require your employee to provide proof that they self-reported their positive case. You might ask them to provide a picture ID next to the positive test so that you know that they're taking a picture of a positive test right there in front of them. So there's another option. Some employers are conditionally accepting at-home tests, saying, okay, don't come to work. You're going to use your sick time until you provide me with a PCR or other validated test from a testing facility. At that point, if you get a positive test, only then will we provide the COVID paid leave. This is a more aggressive approach that has its own risks. So again, I would encourage you that if you're confronted with this issue, consult with your counsel, understand the risks involved, and make an informed decision. Next slide. If I have an employee who tests positive and remains symptomatic after 5 days, do I have to continue to pay the New York COVID leave? This question arises out of the reduction in isolation periods as per the New York State Department of Health. Now, again, neither the statute nor the January 20th guidance addresses this situation. Current isolation rules allow individuals to break isolation after 5 days if they're asymptomatic or their symptoms are improving. Employees whose symptoms are not resolving must continue isolation. The only concrete guidance that we can provide is that the statute provides for COVID paid leave up to 14 days, which is tied to a quarantine or isolation order. Again, these are issues that you really are going to want to discuss with counsel if there are specific situations that are troubling you. Next slide. Do I have to pay COVID leave if an employee is positive but able to work from home? So no, if they are able to work from home, they're healthy enough, even if they test positive and they're working, you don't have to provide COVID leave. However, if they are positive and they are not healthy enough, based upon their own self-reported condition, and they're subject to an isolation order, then they would be entitled to COVID pay. Next slide, please. Do I have to pay COVID leave for an employee who tests positive but who voluntarily chose not to be vaccinated? Again, there's no exception in the statute or the January guidance for unvaccinated employees. All those documents talk about is when someone is subject to a quarantine or isolation order, they're entitled to the COVID pay. So as of right now, there is no there's no distinguishing between those who are vaccinated and unvaccinated for purposes of the COVID paid leave law. Next slide. Okay, so that's it. I'm sorry I went a couple of minutes over. Thank you all again for being here with us. We will take a look at your questions. If you have questions, more specific questions, feel free to reach out. Great to see you, and we will see you again next Tuesday.